Hi, thank you for joining our webinar. My name is Jessie Peterson. I'm the Director of Education here at SunRay Construction Solutions. SunRay secures $10 billion annually for GCs, subs, and suppliers. We're a national construction document service. Today's webinar is conducted by the incredible Kyle Ubel, a Minnesota construction lien law expert. Today's webinar topic is a contractors, subcontractors, and suppliers step-by-step guide to getting paid. So without further ado, I'd like to introduce the fabulous Kyle Ubel.
Thank you so much. Good to be here with everybody. We have an agenda here so we can kind of get everybody oriented on what we're talking about today. So the first concept is going to be talking about your contract, the contract you use either as a contractor or a subcontractor or a material supplier, and the things you want to make sure you have in your contract relative to payment. Then we will talk about how you secure your lien rights, how you secure your bond rights if it's a public project, and some rules and some exceptions relating to both of those topics. And then finally, we'll talk about how you exchange a release when you get a check or when you get a payment. So beginning with contract terms. The most fundamental term in a construction contract is how you get paid, and more importantly, how that payment is calculated. And I've listed here in parentheses sort of the primary or most common project price formats. The first is cost plus, stipulated sum, then a guaranteed maximum price or a GMP contract, and finally a unit price contract. So let's talk quickly about what each of those are just as a refresher. So the first, and maybe the most common, maybe stipulated sum, certainly cost plus and stipulated sum contracts I think are the most common. A cost plus contract is the contractor, the subcontractor keeps an accounting of the costs of the project. They add a percentage fee, and the cost plus the percentage fee, the agreed upon fee, is what the owner pays to the contractor or what the contractor would pay to the sub. For example, if the costs of a project were $100 and you had negotiated a 6% fee, then you'd be paid $106. That's a cost plus contract. A stipulated sum contract, sometimes called a fixed price contract, is exactly what it sounds like. There's an agreed upon price, and even if the project costs less than the stipulated sum, the contractor or the subcontractor gets paid everything. And if the project costs more, the risk is entirely on the contractor or the subcontractor, and they need to eat that deficit. They'd lose money on the project. So there's some risk there. Then there's a blend of the two. That's the GMP or guaranteed maximum price contract. This is a blend of the two. So in the first instance, it's a cost plus contract, but there's a ceiling. So the parties agree that there will be a cost plus up to say $1 million by way of example. But once you hit $1 million, then that's it. And the project has to be completed for $1 million. That's a GMP contract. And finally, you have a unit price contract. These are somewhat more rare because they're a specialized contract that would be used in a particular circumstance. You wouldn't see this in a residential home building contract or even a lot of commercial construction contracts for that matter. A unit price contract is used where the construction is going to involve lots of units or instances of the same kind of work. And the parties agree that each time that unit of work or that instance or type of work is performed, the contractor or the subcontractor will be paid a particular amount of money for that unit of work. So that's the first thing you want to make sure that you understand in your contract, how you're getting paid, and you want to make sure that it matches the current economics of your business. Number one. Number two is the project timeline, which is related to the next point, liquidated damages and consequential damages. So you are responsible under most contracts for performing the work in a particular amount of time, and it'll specify the project timeline or the deadline for the completion of the work. And if you do not complete the work in that period of time, the owner will argue inevitably, if the contract allows them to, that they don't owe you the full contract amount, full price, because you owe them delay damages for not completing the project in time. And they will argue offset against the project price. So there's two things that you can do in a contract to guard against this. Liquidated damages is an agreed upon amount of damages, usually on a per day basis. So if you agree that the project's going to be done on December 1, but it's not done until December 31, that's 30 days of delay. Maybe you agree in the contract that there's going to be $1,000 of delay damages per day. So you'd owe $30,000 in delay damages, which would ordinarily be deducted from the final payment. That's one way to specify the risk of being late. You can plan ahead of time on what it will be, regardless of whether or not their delay damages are a lot higher or a lot lower. You as the construction firm, you will have the ability to plan economically what the cost of delay will be. Or you might say, I'm not agreeing to liquidated damages. Many don't. And then they're simply not available as a pre-agreed upon number. So be aware of that. Are you agreeing to them? And if so, in what amount? And is that amount going to be tolerable to you economically? Or are you simply not going to agree to them? But make sure you have an understanding of that in the contract. The second thing is consequential damages. Consequential damages is the lawyerly phrase for delay damages, the damages you cause if your work is delayed for any reason and you don't get the project done by the specified timeline. Consequential damages is the name for that. That's the name that lawyers give those damages. Those can be waived in Minnesota. And most construction firms, when they contract with owners or when subcontractors contract with contractors, are at least in the first instance going to ask that consequential damages be waived. So if you're piecing this all together, if you have a contract where consequential damages are waived and you have not agreed to liquidated damages, if you've delayed your work and you're late in delivering the work, the project owner will have no remedy against you for delay damages. So that would be a great contract to negotiate, because then you'll get paid the full amount even though you're late. Most owners are going to push back at that if they're sophisticated at all. They're going to say, at the very least, if we're going to waive consequential damages, we have to agree to some amount of liquidated damages. Or if you're not going to agree to liquidated damages, then we cannot waive consequential damages. And if there's a delay, then we'll have to argue about what our actual delay damages are. And if we can prove that the delay in the construction actually damaged our business or actually caused us some kind of lost profits, then rather than an agreed upon liquidated damage, we will get the actual consequential damage. So those are some primary contract terms I'd encourage you all to watch for. Next, let's talk about liens. So once you know what amount you're being paid, once you get the project done on time or you deduct for any delay damages, you now have an amount of money you're owed. Let's assume now that you don't get paid that amount and you need to worry about using a lien as a security interest to leverage payment. Liens in Minnesota are a creature of statute. That means your lien rights arise from a statute in Minnesota, and those statutes are strictly construed with respect to procedure. So you have to follow the procedure to a T, or you lose your lien rights. Liens, mechanics liens, on construction projects are available in Minnesota to anyone who performs engineering work or land surveying work relating to an improvement of real property. And they're available to anyone contributing to the improvement of real estate by performing labor or by providing materials or skills or machinery to the project. So it's a broad group of people who can assert lien rights. If you are required under law in Minnesota to have a license to do the kind of work you do, a plumber's license, an electrician's license, a GC license, you have to hold that license in good standing in order to have your lien rights. If you don't have a license at all, or you allow your license to become lapsed, you don't get the benefit of lien rights. Liens only apply in most states, but certainly Minnesota, they only apply to private real estate, not public real estate. So if you're working on a public contract for a public project owned by a government, the state of Minnesota, a municipality, a county, then we're going to talk about bond rights later. Bonds apply to those projects, not liens. So here we're talking about private real estate. Also, a lot of people say, or say they heard somebody say, that you can't have liens on homesteads. That's not accurate in Minnesota. There is a homestead exemption in Minnesota where under certain circumstances you cannot collect a debt against someone's homestead. That does not apply to mechanics liens. So if you work on a residential building project in Minnesota, you absolutely can assert a mechanics lien right, even though people talk about this homestead exemption. It does not apply here. All right, what do you need to do at the beginning of the project to make sure that you have a lien right? If you're the general contractor, you have to have the pre-lien notice in your written contract. Or if you don't have a written contract, but you should, but let's assume that you don't, then you need to give separate notice, pre-lien notice within 10 days of when the work is agreed upon, when you agree to do it, not when you start it, 10 days from when you agree to do it. If you're a subcontractor or a material supplier, you need to give pre-lien notice via personal delivery or certified mail within 45 days of your first work or your first contribution to the project. Okay, so different timing, different triggering event for subcontractors. The formatting requirements for these pre-lien notices, right down to the font size and the language and the punctuation, it's all in the statute. So get thee to a lawyer or get thee to the statute and make sure that you're using the correct format, okay? All right, now you've done your pre-lien notice, you do your work, you send your final statement, your final pay application, you find out you're not getting paid for some reason, there's some dispute, you're at the tail end of the project now. Now what do you have to do? We need to make sure you have your mechanics lien statement filed. And this is the same for everyone, contractor, subcontractor, material supplier. Now the rules are the same. Within the 120 days of your last contribution to the improvement, you have to file with the county recorder and serve on the owner by a personal delivery or certified mail a copy of your mechanics lien statement. So you have to do two things. You have to file it with the county recorder and you have to serve it. The procedural requirements, again, are strictly construed. If you don't do it in the correct way, you're going to lose your lien rights. You cannot resurrect the 120 days. If you miss it, you can't restart the 120-day clock by going back and doing a little bit of piddly work. That's called the screen door doctrine. And the name came from contractors would go back because they missed their 120-day deadline from when they last finished their actual work. They'd go back and they'd fidget with the hinges on the screen door and they'd say, oh, well, we did more work, so now we have a fresh 120 days, so we still get our lien. And the courts in Minnesota said, that doesn't work. If you're done with your work, you can't go back and do little pieces of punch list work here or there to try to restart your 120 days. So keep that in mind. If you think you're done with a substantial portion of your work, you got a little bit of punch list stuff maybe, don't rely on the punch list stuff to start your 120 days. It starts earlier than that. Now you got your mechanics lien statement filed, the owner knows about it, the owner still hasn't paid you, then you go to your lawyer, someone like me, or whoever else you have in Minnesota, and you ask them to foreclose on the lien. And that can be done in a couple different ways, but there's going to be a proceeding whereby we foreclose on the mechanics lien, similar to the way a bank would foreclose on a mortgage. You're definitely going to need to have a lawyer help you with that. And the priority of which liens get paid first on a project is dictated in Minnesota by the order in which you started your contributions to the project. So it doesn't matter who files their lien foreclosure action first. That's not how priority is determined for who gets paid out of the proceeds first. It's who did work first on the project. Now we're going to talk about bonds. Again, bonds are for public projects because generally you can't assert mechanics liens against a public project. So bonds are used instead. They're used for sure. They can be used on any public project, but they're used for sure on public projects in excess of $75,000. Then a performance bond and a payment bond are required. What's a payment bond? A payment bond is basically like an insurance policy. It's a bond policy that ensures that everybody on the project will get paid. So if for some reason you don't get paid by the government entity or you don't get paid by the contractor, if you're a downstream sub, you will get paid through the bond policy. The performance bond goes the other way. It ensures that the public is going to get their project performed. And if for some reason the general contractor can't get it done, or for some reason material subs can't get their work done, the performance bond steps in and provides funding and resources to make sure that the project gets performed. So they're two related bonds that protect different directions. Finally, you can simply sue for breach of contract if you don't get paid. If I have a contract with you and I say that I'm going to do something for you and you're going to pay me, you don't pay me, I can sue you for breach of contract, whether or not I have a lien against you or whether or not I have a bond protection in my relationship with you. But remember, this is simply a claim for money damages. It's not a secured claim. It's an unsecured claim. And so if the person you're suing for breach of contract doesn't have the money to pay you, you're going to be in a tough spot because you don't have, through a lien or through a bond, you don't have an interest in a different pot of resources to try to get your claim paid. You also can sue for unjust enrichment or promissory estoppel or quantum meruit, which are old sort of Blackstone era common law claims for hey, I did something for you, and even if I didn't have a watertight agreement with you where I can sue you for breach of a written contract, I did something for you, and it's only fair that you pay me for that. So that's sort of your final backstop. Is if you don't have a written agreement, you have a hard time proving who said was going to happen. In exchange for the work that was being performed, you can sue for something called unjust enrichment, which is simply, I did something for you, an appraiser comes in and says, my work increased the value of the property a certain amount, and therefore you owe me that. I would hope that none of you get to that point because you're all using written contracts and you're going to have a claim. At the very least, you're going to have a claim for breach of contract, but you're also going to be doing all the things you need to do to make sure that you have mechanics lien claims or claims against bonds if it's a public project. Finally, promise you finally, the topic of lien waivers. So throughout the project, you're going to be getting progress payments perhaps, or certainly at the end, there's going to be a final payment, and the owner or the contractor, if you're a sub, is understandably going to ask you for a release or a lien waiver. Use a form that you've got approved by your lawyer. These can be a little tricky. There's not a prescribed form that has to be used in Minnesota. Some states do have a required form. Minnesota does not, but you should certainly make sure that your lawyer looks at the form you're using. If you're getting a partial payment, make sure you're giving a partial lien waiver. It's a different form because you're only releasing the portion of the lien that they're paying you for, right? If they're giving you a final payment, and you agree that it's the final payment, then you're going to be giving them a final lien release. You're releasing all of your lien rights. That makes sense. There's also conditional versus unconditional lien waivers. You may have heard those terms. Basically, in Minnesota, regardless of the language of your form, all lien waivers in Minnesota are conditional. What does that mean? It means it's conditioned on you getting paid. So if you give a lien waiver and you haven't been paid, the waiver is not effective. The waiver is not actually effective unless and until you've been paid. So that distinction in Minnesota is not entirely important because the law is what it is, but it's important to make sure that you're giving lien waivers that on the document says that this lien waiver is only effective once you receive payment. And if you don't receive payment, it's not effective. I think that's all I have. Do we have any questions or any Q&A here, Jesse?
Yeah, we actually do have a question that came through. It's kind of a two-part question, so just bear with me. I'll go ahead and read it to you. It says, it's really frustrating. If I haven't been paid, I have to pay for a lien. Can I get these fees reimbursed for the lien? Also, if this is litigated, can I get the attorney's fees reimbursed, or does that have to be in my contract to begin with?
Good question. So you should make sure you have an attorney's fees provision in your contract. It's a good idea, but in Minnesota, yes, you absolutely, in the lien foreclosure action, you can include the court filing costs and the recording costs associated with filing the lien statement, yes. And then in our mechanics lien statute, a lot of people think it's unfair, but it is what it is. The contractor can assert attorney's fees in a mechanics lien foreclosure action. The owner cannot. The project owner cannot. So the answer to your question is yes, you can assert your costs associated with filing the lien statement, and yes, you can assert attorney's fees under the statute, the mechanics lien statute, but it's best practice to have a good attorney's fees provision in your contract. I should add, just it's not necessarily part of the question, but it's somewhat related. It's important that when you file your mechanics lien statement, when you're done doing your work, part of the mechanics lien statement is you have to state the amount that you're owed. Do not round up. Do not overstate that amount. If anything, you want to be a little under what you know you can prove, because if you go to court and your mechanics lien statement is you owe me $150, but you go to court and you only prove $125, not only do you lose your mechanics lien rights because you overstated it, you will then owe as a penalty, you will owe attorney's fees and a penalty to the owner for overstating the lien amount. So it's very important that in Minnesota, you don't round up. You make sure that you put on the lien statement the amount that you know you're going to be able to prove that you're owed.
Thank you. That's a great distinction to be able to make and know about. All right, the next question that came through, it says, can you explain why it matters if a project is 5,000 square feet, and if I'm a sub that should notice the project?
Sorry, you broke up at the end. What was
I'm so sorry. It says, can you explain why it matters if a project is 5,000 square feet and I'm a sub that should notice the project?
I'm not sure I understand the question. I'm sorry.
Okay, maybe we can get some more information from them, and I'll follow up with you about that. Okay, and then the very last question that I see that has popped through here is, when is the deadline to file a Minnesota bond claim?
That would be dictated by the terms of the bond. So when a bond is a contract, just like an insurance policy is a contract. So great question. If you're on a public contract, or excuse me, a public project, you should assume that there's bond rights or bonds that are securing payment and securing performance, and you should ask for copies of the bonds. And then the bond contract, the bond agreement will set forth, just like an insurance policy would, the process for submitting claims.
Okay, perfect. Thank you. All right, so if anybody does think of another question that wasn't addressed, please feel free to reach out and we will be sure to answer any questions for you. Kyle, can you go ahead and switch to the next slide for me, please?
I sure can, yes.
All right, so who's ready to win a gift? We're kind of testing your knowledge. So if you are able to answer these questions correctly in the chat, we'll go ahead and send you a little prize. So take a look. The first question is, who needs to send a Minnesota preliminary notice on a residential or commercial project? And then the second question is, if I am a subcontractor or supplier, when do I need to send a Minnesota lien claimants notice on a commercial project? So take a look at those. If you feel like you know those answers, go ahead and reach out in the chat. If you are correct, we will be sure to get your information from you, and we will be sending you guys over a gift. All right, Kyle, go ahead and switch to the next thing if you don't mind. Thank you. All right, so here are some of the SunRay resources that are available to help you guys stay organized, know your deadlines, and secure your lien rights. Go ahead and scan that QR code to access these incredible resources at your convenience. Next slide, please. All right, please check out our new service. SunRay is offering SR receivables. We will handle your collections for you. We're here to help you guys get paid. All right, our next webinar with Kyle is Wednesday, April 10th at 2 p.m. Eastern Standard Time. It's don't sign a release unless it says this one thing. Please go ahead and register for free at sunraynotice.com/education. And then this one, it's just go ahead and please, if you don't mind, scan that QR code, take a moment just to review us on Google. It does really affect us and help us be able to reach other contractors like yourselves to make sure that they are aware of these webinars and get this information also. And then I think we're on to the very last slide. And that is all we have for you today. Thank you guys so much for everybody that attended. We hope to see you guys at our next webinar. And Kyle, a huge thank you to you. You are incredible. You are a wealth of knowledge. And I hope you guys all have a wonderful sunny day. Thanks
Thank you.
again. All right,
Bye.
bye-bye, guys.